Good afternoon. My name is Bill Wilson, and I'm one of the Wilsons in the firm name Wilson Estate Planning and Elder Law. The other Wilson was my dad, who started the firm in 1963. As you may or may not know, our firm concentrates in estate planning, elder law, and special needs planning. We have offices in LaGrange, Northbrook, and also satellite offices in Orland Park and Warrenville. This afternoon, Michael Drabant will present Preserving Benefits, an introduction to special needs trusts. The webinar will provide a basic understanding of how special needs trusts work and how to maintain eligibility for governmental benefits for people with special needs. After the presentation, there'll be a question and answer period. The presentation part will be recorded, just so you know. And let me tell you a little bit about Michael. Michael is a partner in our firm. He got his undergraduate degree at University of Maryland and his law degree at John Marshall Law School. He also obtained his LLM in taxation at John Marshall with high honors. He's practiced law for 21 years, mainly in the realm of estate planning, elder law, and special needs planning. He's written and presented extensively on special needs planning, governmental benefits, and guardianships. So I present to you Michael Drabant.
All right, thank you, Bill. My name is Mike Drabant, and as Bill mentioned, I'm an attorney here. Just to clarify one thing that Bill said, I've been practicing for 11 years, not 21. Bill accidentally added a decade to my practice, but I appreciate that anyways. So what we're talking about today is special needs planning. So the reason that we talk about special needs planning and special needs trusts is anytime that someone with a disability is going to be receiving funds or property. I say person with a disability, that's usually the appropriate term now rather than disabled person, just so you know. Some people, for families that have a child with special needs or a person with a disability in their family, it's often important to them, which is why we try to use that more appropriate language, the person first language. So, additionally, we're concerned with any beneficiaries who are on any needs-based government benefits, or they might be in the future. Now, the primary ones that we're concerned with is Medicaid and SSI, which is called Supplemental Security Income, which is something you receive from the Social Security Administration. These are the big ones that are the needs-based programs. So for these, the basic rule, this is not the end-all be-all, but generally there is a $2,000 asset limit. If you want to qualify for Medicaid, you can't have more than $2,000 in your own individual name, or else you're going to get kicked off. So generally, when someone is on Medicaid or they're on SSI, we don't want to give them any money, because it's going to, if you give them money, it puts them over $2,000, they're going to then lose their benefits. So just getting into some of the Social Security stuff. Now, a lot of times people don't necessarily know exactly what type of Social Security benefits they're receiving. So I say this is a very common dialogue that I have with many of my clients. So I ask them, what kind of benefits are you receiving? And they'll respond saying, well, I get Social Security. And I'll ask more specifically, and then this is usually their response to my question, because oftentimes they get mixed up with the different types of Social Security benefits. So what I'm going to do is get into that real quickly here in just a minute. So for Social Security types of benefits, the ones we're concerned about for people with special needs is what's called the Supplemental Security Income, also called SSI. This is for a person with a disability. In order to qualify, you have to have a disability that's recognized by Social Security, as well as meeting the needs-based tests. Okay, so you can't have a certain number of assets and you can't have a certain level of income. Now, the other types of Social Security benefits that are out there are not needs-based. Okay, so these are the Social Security retirement benefits that people get who've paid into it over the years after the age of 62. Then there's SSDI, which is called Social Security Disability Insurance. Now, this is for people who have a disability, but they have a work history. They've paid into Social Security throughout the years and they're drawing on that. Then there are also survivor benefits. So sometimes there's Social Security where the surviving spouse, if one spouse is deceased, can still be claiming some certain type of Social Security benefits. Those, again, are not needs-based. So those are not dependent exactly on how much money you have in the bank or how much assets you have overall. Now, one of the tricks that we use if you're wondering about Social Security benefits, or if you are thinking that one of your relatives has Social Security, but you're not sure exactly what it is, I usually ask my clients, well, how much are they receiving every month? Because the current amount for SSI is $794 a month. Okay, so if someone is receiving a check for $1,200 a month, that is not SSI. Now, the 794 is the standard number. It can deviate a little bit. Usually it deviates down, but there can be some deviation for it, so it's not an exact figure. But if their number is way off from that 794, it's probably not SSI that they are receiving. So again, if you have relatives that are receiving some type of Social Security benefits, this is how you kind of figure out whether they're on one of the needs-based programs. So there's a couple other needs-based programs that are provided by the government. These are the SNAP benefits. This is also called food stamps. These are based on income, though, not necessarily how much you have in the bank. There's also the public housing, which is also called Section 8, and then TANF, which is, the temporary assistance for needy families. So again, these are some of the needs-based ones where you have to qualify based on either your income or your assets. But again, the big ones that we're concerned on are still the Medicaid and the SSI. So one other area of confusion that sometimes my clients have is they mix up the terms Medicare versus Medicaid. Okay, so as some of you may know, Medicare is a federal health insurance program if you're over the age of 65, or you can be younger than 65 if you have a qualifying disability, and then you can get the health insurance benefits through the government. Whereas Medicaid, this is a joint program between federal and state that provides health coverage, which is also known as medical assistance, to certain individuals as long as they meet the financial eligibility requirements. And again, the general rule is the $2,000 mark. Okay, so that's the one we keep in mind. So one trick I use to keep these two different is that Medicaid has the word aid in it, and that's for people who they need the aid, they need the assistance because they can't afford it for themselves. Okay, so that's how I kind of differentiate between the two and try to remember that. So again, we're talking about the $2,000 rule. So if someone is on one of these programs, supplemental security income or Medicaid, if they receive a large portion of money, they are going to lose their benefits. And that's something we don't want to do. We don't want to jeopardize that. So our focus is on what's called special needs trusts and planning for people with special needs. So the basic, let's start our real basic, which is what is the trust itself? Now, a trust is a legal entity that can hold assets during a person's lifetime and beyond their death. All right, now this is oftentimes used, if you're familiar at all with any type of estate planning, this is a technique that is sometimes used for the avoidance of probate, so that your estate does not have to go through the probate court process when you have passed away. But for our purposes today, what we're focusing on is what's called special needs trusts. And these are trusts that are designed to supplement a beneficiary's government benefits. Okay, so it's to provide extra stuff. So, basic question is, what exactly can a special needs trust pay for? And so the the general idea is that these are things that are not covered by the government, by whatever program they are on. So the idea, as I say here, is to supplement and not supplant the person's current benefits, because you want to use whatever benefits they are receiving and use the special needs trust as a way to provide the extra. So there's some things like under Medicaid that Medicaid doesn't provide for. So these are things like hearing aids, dentures, clothing, and care advocates. Those types of things are not covered by Medicaid. So either they need to be paid by a relative, or if they have a special needs trust set up, that special needs trust can pay for these things. And they pay for them directly to the provider of the goods or service. Now they can also pay for things like special equipment, therapy and rehab services, training and education, and a few other things such as travel, recreation, electronics. So if they need an iPad or something like that, payments for companion services, because oftentimes that's used for people who are, maybe they're living alone or they're in a facility where they don't have much company, as well as attorney's fees, if there's guardianship that's necessary, court costs, those kinds of things, as well as insurance and burial expenses can also be paid for this. There's restrictions on that, but for the burial stuff, but I'm not going to get into the details of it because it'll bog you down too much with the details. A couple of things that special needs trusts should generally not pay for. Now, generally, we don't want to distribute cash or cash equivalent directly to the beneficiary. So if someone has a special needs trust and it's being administered by the trustee, those distributions should be made directly to the provider of the goods or service. All right, so if you need to pay for, someone's hearing aids, you should pay for it directly to whoever you're getting that from the special needs trust. The other thing you generally don't want to pay for is what's food and shelter, because that is what SSI, supplemental security income, is generally designed to provide for. Now, at $794 a month, how much food and shelter can you actually get, which is why you have the special needs trust to supplement that, because that's a fairly low number compared to what cost of living expenses are. So we are dealing with two types of special needs trusts in the basic format. So what's called the third-party trust is using someone's assets that are not the person with the disability. And then the other type is called the first-party trust, which is funded with that beneficiary's own assets. So the person with the disability is funding it with their own money that they have received. So the third-party special needs trust. The classic scenario, this is, if you've ever heard of a special needs trust, chances are this is the type you've heard of. Okay, so this is where a married couple comes into my office, they have a couple children, and one of their children has a disability and is currently receiving some type of government benefit like SSI. Now, what we're trying to do is we want to provide financial security to that beneficiary who has the disability without risking any of their government benefits. So that's the goal here, and that's why we do special needs planning. So this is how it works when you set up this type of third-party special needs trust. So they come into my office, they sign it, then the trust is funded with assets. So the married couple, my clients themselves, are the ones who are putting money into the trust themselves. And this could be done either during their lifetime or after their death. It could pass under a will, or it could pass under another trust. Usually, my clients are the trustees during their lifetime, so they're the ones who are in control of the funds. And the successor trustee, once my clients have passed away, needs to be someone other than that particular beneficiary. So the beneficiary himself or herself cannot be in control of any of these assets. Now, and what I say is that this can be amended or revoked by the grantors, which are the people who set up the trust. Those are my clients in this scenario. Now, just continuing, the trustee can make those distributions on behalf of the beneficiary. The trust will stay in existence throughout that person's lifetime. And then once the beneficiary, the person with the special needs, has passed away, the remainder of those assets are then distributed to whoever my clients have specified. Usually, they want it to go to their other children. So they say once child A has passed away, they want it distributed to our other children or to our other descendants or grandchildren. And then that's how it's done once that beneficiary has passed away. And this type of special needs trust is the preferred version because there's no payback to the state, meaning Medicaid will not have any claims against the trust assets when this beneficiary dies. So that's very good because Medicaid, that bill can sometimes be very large. So we have two common scenarios. Sorry, let me get into now we're switching gears to the other type of trust, which is what's called the first party special needs trust. So these are two scenarios that are the most common. So either someone who is on benefits is going to receive an unexpected inheritance. So this is like some other relative is giving them money, or someone who's on government benefits, someone with special needs I'm talking about, is going to receive a personal injury settlement. Now, this type of trust has some other names. So if you're at all familiar with it, you may have heard it called an OBRA trust or a self-settled trust, the payback trust. Those types of things are what this is also called, because there's just two different general types, either third party or first party. And again, remember, this is funded with that person's own assets, the person who has the disability. So in this scenario, we say, I myself say I have a child who has special needs and they're receiving benefits. And some other relative, my aunt, dies and leaves money to my child under her will. But she didn't do any type of special needs planning. So it's just an outright distribution going directly to my child. Now what we have to do is we have to act fairly quickly to get something in place so as not to jeopardize those benefits. Now, this is only available to people who are under the age of 65. That's one of the weird sort of quirks that's in the statute. The rest of it is that they have to have the disability. It has a payback provision to the state, meaning that Medicaid, the Department of Healthcare and Family Services, they will have a claim to these assets when that beneficiary dies. And there's only certain people who have the legal authority to set up this type of trust. And that's listed here in the slide. So when we create a first party trust, this is how it works. It's signed, it's executed by one of those qualifying individuals or a court. The trust is also signed by whoever is the named trustee. Then you're going to apply for a tax ID number, also called the EIN, and you're going to create a bank account in the name of that trust. Now, once that trust account is established, those funds that are receiving from my aunt, so my aunt's will is sending money to my child, those funds are going to be directed into the new trust account within the same month that they are received. Because if you do that, you will not have any risk of loss of benefits. But if you put it into my child's name and you let it sit there for several months, you're going to lose benefits. We also have to notify Social Security. We have to notify Medicaid when we do this type of thing, because you have to tell them that you have received assets, and you have to tell them what you're doing with those. So again, just like the other type of special needs trust, the trustee makes distributions for the beneficiary's benefit. And then after the death of the beneficiary, the trustee has to contact the Department of Healthcare and Family Services to determine the size of the lien that DHS is going to have, because they are entitled to payback for any Medicaid benefits they have paid throughout that beneficiary's lifetime. So oftentimes those payoff amounts are huge because it's the entire lifetime of that beneficiary. You also have to pay off any other states that have paid out benefits. So in case this beneficiary used to live in Indiana or Wisconsin, you've got to contact those states and figure out how much money they are owed when the beneficiary actually dies. So again, let's review. We have the third party special needs trust, I abbreviated SNT. That's funded with someone's assets other than the person with the disability, and it does not have a state payback provision. So the state does not get paid out of this special needs trust, which is why it's the preferred method. The first party special needs trust is with the beneficiary's own assets, and it has to contain the payback provision to the state. So another way I think of this is the third party one, that's being proactive. We're planning in advance, okay? So we're anticipating, we're trying to avoid problems in the future. The first party one is reactive. So the money's already on its way and we need to do something about it because otherwise my child is going to lose their benefits. So one quick alternative, because sometimes with special needs trust, there are other options depending on the amount of money that you are going to receive. So say, for example, I say here, we can do what's called the spend down. And that's where a client is on Medicaid and they're going to receive an $8,000 inheritance, okay? Now that's gonna push them over the limit. Remember the $2,000 limit that they're not allowed to have more than that. So what you can do is you can deposit that money into the beneficiary's own account. In this scenario, there is no special needs trust set up. We're just talking about a spend down. So you put it in that person's own bank account. You spend $6,000 of that money during that month. It's got to be spent before the end of the month so that by the end of the month, you have $2,000 or less in the account. And if you do this properly, they will not lose their benefits, but you still have to notify Medicaid that you've done this. You have to show them the receipts, you have to show them the bank statement showing money in and money out, okay? Now, sometimes this is better when there's not a huge amount of money coming in because it's more economically efficient. So if the person is receiving a fairly small inheritance, maybe this is a better route to go. But if they're going to be receiving anything that's substantial, then we probably do need to do some type of first party special needs trust. So that is the conclusion of my portion of what I have today. I've thrown a lot at people.